Good afternoon. My name is Paul Yokabitus. I'm an estate planning attorney with Stevenson Law in Cary, North Carolina. And I wanted to take a moment to kind of go over a common question or misconception, I guess rather is more appropriate, from clients that I meet with in my office. I do comprehensive estate planning, which includes wills and trusts. It includes business planning, special needs planning, and asset protection planning. And one thing I hear often is people come in and they say, I need a will so that the government won't get my money. So I wanted to take a moment to kind of discuss that and flesh that out. So when we talk about the government getting your money, it can come in a couple different ways. So normally that's going to be in the form of taxes. So assets being taxed, or you paying capital gains tax and those sorts of things, or something that your family can anticipate when they receive your assets after you pass. The other may entail paying fees to the government in the form of a probate fee. So let's take a couple minutes and kind of flesh that out. So first off, the taxes that you may encounter, or that your family may encounter, are going to be estate taxes or capital gains tax. So estate taxes are purely on the federal level in North Carolina, as North Carolina has repealed their estate tax several years ago. So there's no state level estate tax any longer. There hasn't been for about 4 years. So as far as federal estate tax, we're really only talking about like a 0.01% problem. The reason I say that is because most people are never going to have to worry about estate tax. The current federal exemption amount, and what I mean by exemption is that every dollar that passes below a certain threshold will pass without being taxed, without being subject to estate tax. So the current exemption amount in the United States is $5.49 million for 2017. So that's per person, per individual. So that amount is doubled for married couples. So every married couple, the surviving spouse, will have a lifetime unlimited exemption for receiving gifts and assets by way of estate succession from one spouse to the other. So whether it's a lifetime gift, transferring assets to the other spouse, or by virtue of one of the spouse dying, the surviving spouse will receive those assets without them being subjected to estate tax. So we're really talking about when the second spouse dies. At that point, the first really $11 million, it's about $10.98 million, is passing tax-free to your beneficiaries. So you're really only being taxed on every dollar above that. So you'd have to have 10.98 and $1. And every dollar at that point is taxed at 40 cents on the dollar, or 40%. So for the most part, people don't have to worry about that. But more importantly, wills don't have any impact on that. So the reason for that is taxes are calculated on what's called the taxable estate. Taxable estate is anything that you own or any value that you have on the date of your death. And that may include personal property, real property, IRAs, 401ks, 403bs, life insurance that's owned by you in your name, and things like that. So it's really calculating everything that you own, or everything that its value is calculated on your life. Well, your will has no impact on that. The will is going to direct your probate assets, and assets that are considered probate assets are going to include anything you own individually on the date of your death. So it's really going to be personal property. It's really going to be bank accounts, brokerage accounts, vehicles, home furnishings and personal effects and stuff like that. So what a will does is it directs the distribution of those assets after you pass, and it's only effective upon passing, upon death. So it does not, however, take assets out of your taxable estate. So whether you're subject to estate tax or not is not going to be changed by having a will or not. So the other tax we talk about is capital gains tax, which is going to be essentially tax on profits. So things that are held that have appreciated. So it could be stock that you've owned for 10, 20, 30 years. and say Coca-Cola. So if you have a cost basis in your stocks at, say, $70 a share, and I'm just spitballing, I don't know what the current trading value of Coca-Cola stock is, but say, for example purposes, you have Coca-Cola stock that you bought at $70 a share 20 years ago. Well, over the last 20 years, it's doubled in value. So your tax basis is $70. Well, if it's worth $140 per share now, you have a $70 gain on every share. So if you were to sell it, you're going to have to pay long-term capital gains tax on that. Currently, it's around 23%, and you add to that the state level, which is about 5%. So that's capital gains tax generally. So when you pass appreciated assets by virtue of your death, your family currently, under the current tax codes, takes that on a stepped-up basis. Now, let's get more definitions down. Stepped-up basis means that they're going to have a cost basis at the current fair market value when they receive the property. So if it's worth $140 today, that's their new tax basis if you were to pass today. So if they were to turn around and sell it, they would have zero tax base, or zero's tax liability, because there's no gain. So by virtue of transferring property by virtue of death triggers that step up in basis. So if you were to gift those assets during your lifetime, your beneficiary, whoever you're giving it to, takes that property at your cost basis. So after you pass, if they were to sell it, if you gifted it to them the day before you passed, they would have to pay capital gains on that $70 gain, a $70 profit. So those are the two types of taxes that we normally deal with, neither of which are going to be really impacted by a will. So whether you have a will or not, people are still going to receive your property after you pass. It's just a matter of who and how. So if you don't have a will, the state's default rules are going to control who your beneficiaries are, how much they're supposed to get, and in what form. So what a will really does is it takes that decision or those rules out of the state's hands and makes them your own rules. So you make your own rules, and you can decide who gets your property, how, and in what amounts. So wills don't have any impact on taxes really at all. So state tax, one, is really not going to be a problem that a lot of people are going to have to deal with to begin with, but a will not have any impact on a state tax. The other, capital gains tax, a will is also not going to have any impact on it. It may facilitate a step up in basis by virtue of directing a transfer of property at death, but most people, if that's the case, are not going to be paying taxes anyway if they're receiving property by virtue of death. So then, now with the taxes out of the way, the government's not getting your money through taxes, then we talk about probate fees. So whether you have a will or no will, your estate is processed through the clerk of court in the county where you resided and had every intention to reside on the date of your death. So normally that's going to be where your permanent residence is, where your home is. So I live in Apex. My office is in Cary. My domicile is Wake County. So if I were to pass, Wake County would have exclusive jurisdiction over my estate. So if you don't have a will, your estate is still processed by the clerk. It's just by the state's rules, not yours. If you do have a will, you enter what's called, or your state enters what's called probate. And that's the process of settling your estate according to your rules as set out in your will. So in that respect, whether you have a will or not, the same process really applies. It's a matter of whose rules are controlling. So during that process, the clerk is entitled to a probate fee of 0.4% of personal property assets in the estate. So if you were to pass away with a $1.5 million brokerage account, and that was subject to probate and had to go through the court process, the clerk would be entitled to a $6,000 probate fee. So that is an expense that's paid from your estate. It's not something that's individually incurred by your family or by your beneficiaries themselves. It's essentially taking it off the top from the proceeds from your estate that they would have otherwise realized. So that is a very real cost, and that applies across the board. It's a minimum of $15 and a maximum of $6,000. So again, to max out the probate fee, you'd have to have $1.5 million in probate assets. So, and again, a will is not going to impact that. So if you have a will or not, that fee is still going to be due and owing. It's just a matter of controlling, who gets your assets on the back end, where the proceeds go. So this conception that a will avoid, having your money go to the government is mistaken. The very last way that's a non-tax or non-fee way of the government getting your property is if you just simply have no beneficiaries. If there's no one left in your family, and you haven't designated a charity or a church or some other worthy endeavor, or even friends, neighbors, co-workers, however you deem necessary, if you don't have a contingent remainder beneficiary designated in your will, then the Sheets law may apply, where essentially your assets are surrendered to the state and they can use them really however they deem necessary. So that's usually, again, not going to be the case. Most people, even if they don't have a will, are going to have heirs at law, which are people who are going to take by virtue of their relationship to you. Usually they're going to be blood relatives, whether it be parents or grandparents or siblings, children, grandchildren, that sort of thing. So that's a very remote possibility. But to kind of circle back, wills may prevent a Sheets from happening, but they're not going to have any impact on whether a probate fee is due and owing or whether the government is going to take any sort of taxes from your property. So the way to avoid those sorts of fees associated with the probate process is just avoiding probate. So the way we do that is we use either non-probate designations, so transfer on death, payable on death, joint tenant with right of survivorship, or we use trusts to move your probate assets into a non-probate designation. So in that sense, the trust totally bypasses probate. So you can save that fee. So while the will to avoid fees is misguided, if your intention is to deprive the court of a probate fee, the only way to do that is to avoid probate. So the best way to do that is to get the ball rolling, so to speak, and set up a meeting with a lawyer to discuss your options and see what's in your best interest as far as planning is concerned. But you can't do that unless you take that first step. It's kind of like playing the lottery. If you don't play, you can't win. So again, my name is Paul Yokabitus. I'm an estate planning attorney in Cary, North Carolina. And I help people through these issues. Whatever their wishes or fears may be, I help them resolve it through legal planning, essentially. Not just wills, not just trusts, but overall comprehensive legal planning. So if you're interested in learning more, you can visit my website, www.caryestateplanning.com, or give me a call, 919-858-7008, or an email, pay@stevenson-law.com.